Hello, and welcome to another installment of Closing Arguments. I'm your host, Ryan Ruff. It's great to have you back for another edition of the show. I've got really the star of our show in Mr. Jack Razumich, or, as most people call him, Jack, formerly John Razumich, but we'll go by Jack today here on the show. But look, hey, we're so excited to have you with us today, whether it be on the Facebook live stream or after the fact on a podcasting platform, maybe a YouTube channel after the fact. All the same, happy to have you with us for today's conversation. If you are checking us out on the Facebook live stream, feel free to leave a comment or even a question below. I'll be monitoring that throughout the course of the show. We'll take a few minutes at the end of the show to answer some of those questions and comments. But either way, we'd love to have you chime in and even kind of hear where you're listening from today. Now, into the topic at hand today, last episode, Jack and I covered the Miranda warnings. There was a lot to unpack within them, where they first came into fruition within criminal law as a whole, and then additionally how they've kind of molded really into what we see them as today. But today we're going into the backside of things. What happens after a conviction? That's really the overarching theme of today's show, but we're gonna dive into a few different elements within that. First of which, we're gonna go into what the appeals process is, what it looks like, how it impacts what Jack does on a regular basis with Razumich Associates. Additionally, we're going to go into the topic of post-conviction relief, what this looks like from, a defendant or an individual facing prosecution, what this looks like from their side. Additionally, sentence modification will be the final theme that we're going to cover today. So with that being said, let's go ahead and bring Jack on to get today's conversation rocking and rolling. Jack, great to see you. How you doing today?
Hey, Ryan, good to see you again. Have we worked out the whole soundboard thing with having the Price is Right music when we actually bring me out on that?
I'll make it happen in post-production today.
We need to see about getting that done. Seems like it's just like, hey, here you are,
Jack Razumich, come on down. We need it. I love that line. It's
right.
Too good. But hey, look, Jack, great to have you on with us today. Obviously, this is a good conversation, one that's going to kind of continue to lay the foundation from some of these earlier episodes that we're having here for Closing Arguments. Really, for the first theme, as I just mentioned, really, we're going into the conversation of what happens after a conviction. Our first theme that we really want to get into is the appeal process. So, right, somebody's convicted of a crime, they can certainly appeal that conviction. So walk us through, what this appeals process looks like. When can someone appeal a case? How do they go about doing it? Give us that 10,000-foot view of this appeal process, if you will.
Sure. When a trial's done, just because a trial's done doesn't mean it's done. In the state of Indiana, in most states, actually all states, now I think about it, if you are convicted after a trial, everyone has at least one appeal of right. That means that you have the ability to appeal it up to the next court down the line. I think at this point in time, all 50 states, as well as the federal circuit, do have what's referred to as an intermediate court of appeals before their individual Supreme Courts. So if you get a decision that you don't like, you go to trial and you're convicted after trial, you do have the right to appeal that determination up to the next court along the lines. That's referred to as a direct appeal. And that's what most people think about when they consider the appeals process, is that direct appeal to the next court up. So, for example, here in Indiana, if you proceed to trial and you lose at the trial, you can request the ability to appeal that decision to the Court of Appeals. And the procedure that's involved in that is once the judge will make their determination. If you have a bench trial, the jury will make their determination if you're having a jury trial. And once the sentencing is done, that's where the clock starts ticking in Indiana for the purposes of filing your appeal. So it's not from the date of conviction, it's from the date of sentencing. That's where Indiana's procedural rules calculate where the time limit starts. You've got a very, very limited window to be able to pursue an appeal in Indiana. You have 30 days from the date of sentencing to appeal that decision up to the Court of Appeals. And as far as what you can appeal, you can theoretically appeal anything that is legally possible to be appealed, which is probably the most lawyerly answer you can get, but that's effectively how the process works. Trial courts in Indiana are considered to be triers of fact. That means that the trial court is the one that makes the determination as to credibility of witnesses,
Mm-hmm.
judgments on evidence, things of that nature. The courts of appeals are considered to be triers of law, which is the more ivory tower aspects of this. Um, what the Court of Appeals does is when you are appealing a decision from the trial court, you're not allowed to ask the Court of Appeals to reweigh the credibility of a witness or rejudge their testimony. You're asking them to make determinations as to whether or not something legally impermissible happened at your trial. One of the
Mm-hmm.
primary things that gets appealed, for example, is jury instructions. If your attorney submits jury instructions and the trial court says, I don't really want to give this instruction, it's covered by something else, or I don't think this is appropriate, that's the type of thing that you appeal. You would make the argument to the Court of Appeals that if this instruction had been given to the jury, the outcome might have been different.
Mm-hmm.
And the Court of Appeals determines that as an issue of law. Same situation if the prosecutor's office gives an instruction and your attorney objects to that instruction being given. The appeal on that issue would be this instruction was given erroneously. If this instruction had not been given, the jury might have ruled differently, and that's what the Court of Appeals looks at. They also look at issues of admissibility of testimony.
Mm-hmm.
Um, that is actually why attorneys object in trial.
Sure.
Is that's kind of the secret behind the curtain aspect of it. Procedurally, if an objection is not raised, an objection is a question of law. You are saying that I
Mm-hmm.
object because this is not permitted under this law. And that's what the Court of Appeals looks at. So if you don't object, that's what the attorneys are doing. If you're not objecting, you
Mm-hmm.
can't appeal that issue. And
Got it.
that's it's very complicated perfecting a trial record for appeal.
Sure.
Ideally, we don't want to do it. We really want to not have to put our clients in the position of appealing a case.
Mm-hmm.
Sometimes that happens though, and that's what gets appealed. Is that record of what objections were or were not there are considered.
Got it. So in this world of appeals, Jack, I think what most of us, the layman, really that's kind of privy to is, okay, if an appeal is granted, and it's this game of law related tennis with appeals. You're bouncing the appeals through different court levels. The big question is, how does something get to the Supreme Court level? How does the Supreme Court ultimately consider your case? What does that ladder look like when it comes to appeals rising up the ranks to finally be looked at by the Supreme Court?
Well, you've got two different tracks that can take. With regards to your state Supreme Court, as I said, everyone's got one appeal as a matter of right. Everyone can appeal their case to the Intermediate Court of Appeals. State Supreme Courts, as well as the Supreme Court of the United States, have a significant amount of discretion over what appeals they do or do not accept. In the state of Indiana, if you want the Indiana Supreme Court to review the case, you would do what's referred to as a petition for transfer. That's the legal terminology that we have in Indiana. If you want the Supreme Court of the United States to look at it, you file what's referred to as a petition for certiorari, which I'm sure has a translation from Latin to English that I simply don't know. The law is full of phrases like that.
Oh, sure.
The on the state side, it's a lot easier to get a state Supreme Court to review your case than it is to get the United States Supreme Court, because most criminal prosecutions are, for very obvious reasons, they're brought under state law. And as such, the individual state that your case is in, that state Supreme Court is going to be the final authority on the state law. To get a state Supreme Court to look at your case, you usually have to make an argument that there is that the decision of the Court of Appeals was in violation of a prior Court of Appeals decision or a prior Supreme Court decision, or that there's some sort of novel issue of state constitutional law or state statutory construction that the Court of Appeals ignored.
Mm-hmm.
One of my cases that I think I've had, I think that I have had two cases out of my trials that got appealed up to the Indiana Supreme Court. One of them dealt with jury instructions, which was one of the things we had talked about before. Um, And another one dealt with an issue of prosecutorial misconduct that went up on appeal, and those both stopped at the state level. To
Mm-hmm.
get the Supreme Court of the United States to review your case, you have to make an argument that there is an important constitutional right that is impacted, that the state has ruled is somehow in violation of the federal law. So, going back to our last episode, the Miranda decision, one of the reasons the Supreme Court of the United States reviewed the Miranda decision, or the Miranda case, Ernesto Miranda's case,
Mm-hmm.
is that dealt with an argument that he was being denied his constitutional right to representation, his right to remain silent under the federal Constitution. If that argument had not been raised, there would have not been a basis to get it in front of the Supreme Court of the United States, because they don't have any control over Arizona's procedural laws, procedural statutes, as long as they don't violate the federal Constitution.
Got it.
Most cases, whether an individual defendant wants to acknowledge it or understand it or believe it or accept it, most state cases typically will not involve federal constitutional questions, even if there is, let's say, a Fourth Amendment issue. There are a lot of cases that on the trial court level, you can argue that evidence is admitted in violation of search and seizure prohibitions. Most states will have comparable state constitutional amendments that the federal ones do. So, for example, the federal Fourth Amendment, the Indiana version of that is Article 1, Section 11. That's the Indiana version of the Fourth Amendment. Procedurally, when you're making an appeal, if you're making a constitutional argument that evidence is presented impermissibly, you would be a pretty bad trial attorney who did not make a record, and a very bad appellate attorney who did not make a record on both the state and federal constitutional claims. And overwhelmingly, state Supreme Courts or state Court of Appeals will prefer to resolve any constitutional issues under their individual state statutes and under their own state constitutions. The reason for that is the Supreme Court of the United States will give a great deal of deference to the individual states. And if they can avoid taking a constitutional question because they looked at the briefs and said, oh, well, their state constitution seems to be perfectly hunky-dory with this. Mm-hmm. One less case for us to have to worry about. They'll usually try to punt it that way.
Sure. The less that gets pushed off to them, the less eyes, I guess, ultimately are on the case and the impact that it'll have on a federal level. So thank you for kind of breaking it down, what that ladder looks like to get up to the United States Supreme Court level, let alone the Indiana State Supreme Court level. But I guess my final question, in regards to the appeal process is, what happens if an appeal is successful? Is it that, hey, this is getting bounced back to the court? What is ultimately the physical result of a successful appeal?
Generally speaking, not much. It depends on the nature of the appeal, the offense that's being appealed, how that process is laid out. Unlike what you see on television or how the press as a whole reports it, courts of appeals don't actually exonerate defendants. Again, remember, all that a court of appeal is doing is ruling on an issue of law. They're ruling on, was this permitted under law to be presented to the jury? That's all they're ruling on. So, using the jury instruction example, when I had a case a number of years back that went up to the Indiana Supreme Court on the issue of jury instructions, what the Indiana Supreme Court said is like, yeah, these jury instructions bad. These jury instructions should have been given. Go back and do it over. And what happens with that appeals process then is it goes back down to the trial court level, and the prosecutor at that point in time has to make a determination as to whether or not they want to retry the case, or the parties are free to reach a new agreement. If they want to reach a new plea agreement, they can certainly do that. But that's what happens if an appeal is successful. If an appeal is successful, you basically go back to the day before the trial started. and everyone's in
Got it.
determination at that point in time of, okay, do we schedule this for another trial using the new guidance that was just given to us? Do we not want to go to trial at this point in time? And that's the determination that's there. It's also worth noting that I believe the last statistics that I saw were that something like 11% of criminal appeals are actually successful in the state of Indiana. So if you successfully appeal a determination, first of all, one, it may not necessarily feel like it to you, but man, that's a huge victory because
Sure.
the odds are really, really against you to actually get that appeal to go your way.
Hmm.
But it's not the end of the process. All that happens is you go back to the day before the trial and you have to make your determination as to what direction you do or don't want to do. And it's actually kind of a fascinating dynamic at that point in time.
Hmm.
Direct appeals like this usually happen in a short enough period of time that it's not impossible to retry the case.
Okay.
Um, so the witnesses will still be available, the evidence will still be available. I think that on average, your intermediate court of appeals case, you're looking at about 6 to 9 months from the date the appeal is filed to getting a decision back. That's just at the
Okay.
Indiana Court of Appeals level. Obviously, if it goes to the Supreme Court, that can take more time.
Right. Right.
But that's not that long of a period of time. Again, remember what we talked about with the Fast and Speedy Trials episode. Some of these cases can take years to get done.
Oh yeah.
So 9 months to be told, oh, well,
Drop in the bucket.
yeah, it's like go back to like the day before the trial happened. 9 months is nothing,
Sure.
and smart prosecutors will basically kind of keep an eye on the situation, keep an eye on the briefs, get an idea as to how the arguments are going to maybe stay in contact with their essential witnesses, the essential evidence that they might need, if
Hmm.
it has to happen again.
Got it. Got it. So the appeals process is a super interesting one because everybody, in like you said, in most instances the appeal option exists. But I want to shift into our second theme now of the conversation today, and that's this idea of post conviction relief, or PCR. I think the best place to really start with this, Jack, is to first tell us what it is. What is post conviction relief? How does it apply to different court cases and criminal law cases? But also, how does it really differ from the appeals that you just walked us through? Could you give us that kind of high level overview?
Right. Post conviction relief it's a civil proceeding. A criminal trial is, of course, a criminal proceeding. A direct appeal, even though it's an appellate situation, is still considered to be it's a criminal aspect of it. Post conviction relief is a civil proceeding. Effectively, you are having a trial on the trial. When you are filing a post conviction relief petition, you are alleging that that your incarceration or your conviction is in violation of the state or federal constitution for one reason or another. The primary reason that you'll see someone file a post conviction relief proceeding is that they're alleging that they received ineffective assistance of their trial counsel. The idea is that the trial attorney was so deficient in his or her performance that any reasonable defense attorney would have done a better job, and the jury would have likely come up with a better determination or a different decision than what actually was.
Mm-hmm.
That's the single most common thing that you'll see for a post conviction relief proceeding. The second most common thing that you'll see with a PCR is an argument that there was newly discovered evidence that was not capable of being located with due diligence at the time of the original case.
Oh,
So,
okay.
those murder cases or sexual assault cases that you'll see where they've been in jail for 20, 30 years, but there's new
Mm-hmm.
DNA testing and they're doing the DNA testing that's leading to exonerations. That's what that is. That's
Sure.
that's a post conviction relief, which for the benefit of anyone who's listening outside of Indiana, post conviction relief is what we refer to as in Indiana. In the federal system, it's considered to be a writ of habeas corpus. More people are familiar with that term because, again, that's something that is popularized in the press. But it's the same type of proceeding. You're arguing that your incarceration is in violation of state or federal law. And that's what's happening with those cases with the DNA testing years and years later is the attorneys are arguing, hey, it was impossible for us to have this evidence 30 years ago. The changes in the science have been so great that
Mm-hmm.
we could not have had this even if we knew that it was something that could exist. We know it exists now. We think that it's going to make a difference, and we want to do this testing. So
Right.
there are a couple of other grounds, but those are the two primary grounds that you usually see with the post conviction relief.
Got it. So my next question kind of leads into kind of, I guess, the inner workings really of PCR, in that how many times could PCR essentially be filed within a given case, or better yet, to kind of mix the two themes that we're discussing here today. Can a PCR finding be appealed? Like, how does that work? How often do you find PCRs popping up in a given case, and then also can they be appealed when introduced to a case?
Sure. The short answer is you can have as many PCRs as the court feels like letting you have.
Mm-hmm.
It's like any other civil litigation. If you sue your neighbor for hitting you with a car, and that litigation doesn't go your way, but you have a new ground for trying to sue him again, because it's civil. There's not a double jeopardy situation in civil law. That's a complete criminal aspect of it. So, as a practical matter, you really get one PCR, because to get a subsequent PCR, you need the court's permission to file it, and you have to have unique grounds that you could not have raised the first time around. An example would be, again, just using the basis of ineffective assistance of trial counsel that we talked about. That's the number one thing that you usually see with a PCR. Um, if you can go and convince the judge that your post conviction relief counsel was ineffective, you can presumably get the court to authorize a second PCR filing, but those start getting incredibly rare. It's one of those things
Sure.
that the court wants to make sure the procedures are being followed, um, but there are limits. It is one of those things of they're not going to allow you to file the same case over and over again, unless you have something new that you can show affected the situation the first time around. They're not going to give you a second shot at it. A PCR can absolutely be appealed. It's an original case. It's civil instead of criminal, but the same general rights of appeals apply. You can appeal the PCR, as a matter of right. You get one appeal as a matter of right, which is your direct appeal concept. And if you're going to appeal a PCR, there's one special claim that gets raised in the appeal for the first time. Generally speaking, you cannot raise appeals. You cannot raise issues in appeal that were not raised at the trial court level. With a PCR, if you are appealing the PCR, you are allowed to make a special claim in that appeal that says that you had ineffective assistance of appellate counsel. So even though that's not something that you would raise at the trial court level, if you were appealing a PCR, that's where you would throw your ineffective assistance of appellate counsel in. And the general rules with appeals actually still apply. You've got the appeal of
Okay.
right. You can petition it to the state Supreme Court for review.
Mm-hmm.
Um, you cannot, as far as I am aware, and in full disclosure, my office does not handle appellate work of any type. We do handle PCRs, but we handle them at the trial court level,
Okay.
because we're trial attorneys here.
Mm-hmm.
So take this with a grain of salt. As far as I am aware, you cannot directly appeal a PCR to the Supreme Court of the United States. It
Okay.
is possible to get your state case into the federal system through that writ of habeas corpus.
Mm-hmm.
Because if you're alleging that your incarceration is in violation of state or federal law, that gives you an ability to file a habeas corpus in the federal courts, and that does put you on that ladder to try to get to the Supreme Court. There are procedural rules and thresholds that have to be met.
Mm-hmm.
In Indiana, at the trial court level, you effectively say, "Hey, here's the issue that I'm arguing about. This is the legal standard that I'm looking at. This is why I get this PCR." to transfer that over to the federal system, you have to fit under it was a law that was passed in the early years of the Bush administration.
Mm-hmm.
It's AEDPA, if I recall correctly. Don't ask me what that actually stands for because I can't remember right now. But it's a federal law that basically controls when the federal courts can review state habeas petitions. It primarily focuses on death penalty cases, of course, but other state cases can get in that if they fit under the umbrella of that statute. Same situation, they can get in the federal system that way.
Gotcha. So round it out for me here. Just as we did with appeals and what happens when appeals are successful, what happens ultimately if PCR becomes successful?
Pretty much the same thing, but the dynamic as to what direction you want to go is very different. Um, Much like with an appeal, the court, if the court finds that a PCR should be granted, the court's not going to turn around and say, okay, that's it, no more trial, you're done, get on out of here, don't commit trouble again. What happens is it does go back to the prosecutor's office for the purposes of determining whether or not they want to retry the case. And where this becomes a bigger issue is, again, like I said, some of those PCRs will happen 5, 6 decades after the actual conviction.
Right.
That can be a problem for both sides on the process of what they do or don't want to do. With the murder cases, a lot of times, and you'll see this with like the really big ones that make a lot of press. You saw this with the Central Park Five. When their cases were overturned, their convictions were overturned through the post conviction relief process, through the habeas process. And what happened is it went back down to the trial court level, and the prosecutors had to make the determination as to, okay, do we want to retry this case? And this is, a good 20 plus years down the line at this point in time. Because
Mm-hmm.
again, they were exonerated because of DNA evidence, which was not available in the early to mid 80s, or at least not available as we understand it right now. So what happened, and this is unfortunately the tragic effect of the criminal justice system sometimes, because the system cannot admit that it made a mistake. Somehow psychologically, the system seems to think that if they admit that they made a mistake, the process will come crashing down on them like a house of cards. So what happens is you get a case that's vacated, you get a conviction that's vacated because of a PCR, goes back down to the trial court level, and the prosecutors will pretty frequently say, okay, you've spent 15 years of your life behind bars. Sign this plea agreement admitting that you're guilty and go home today, or we'll retry the case. So it becomes a game of
Mm-hmm.
chicken with that. And, I get it. That's hard. If you've just spent that long in prison for something that you didn't do, being
Yeah.
told you can go home today, that's a hard thing to say no to. But that is the tragic part of a PCR,
Mm-hmm.
is that if you win the PCR, you may not actually win, because they're going to send it back to the trial court, and the prosecutor will say, I still want your conviction. And then you have to make the determination, okay, do I sign this plea agreement, go home? Do I
Yeah.
stay and try another trial? It's
Mm-hmm.
it's not it's There's not a good answer on that one.
Sure. No, a tough situation for sure. So, Jack, we've now covered the appeal process. We've covered post-conviction relief. Let's get into the sentencing of everything now. So, a sentence is dealt out, but sentences can be modified. There is sentence modification. So, how can a sentence be modified? What all goes into this process? How does a judge ultimately play a role in this as well? And this will kind of round out our conversation. This third and final theme for our episode today.
Sure. Sentence modification is, if you think that winning a direct appeal is complicated, if you think that winning a PCR is complicated, you have no idea how hard it is to win a sentence modification. You can get a sentence modified through a direct appeal. If you'll recall from a few moments ago, one of the things that we talked about was that the clock starts ticking after your sentencing date. Your sentencing date is where the clock starts ticking on that 30 days to make your appeal. You can appeal the sentence. That is one of the things that you are authorized to appeal. That is an issue of law. It falls under Indiana Appellate Rule
Right.
7B. And the Court of Appeals can reduce a sentence. They can also increase a sentence. So it's a little bit of a crapshoot, but you can appeal whatever sentence the court actually imposes after trial. So that's your first avenue of arguing for sentence modification is through a direct appeal with the Court of Appeals. That's usually not successful. And the reason for that is under the way that the Court of Appeals and the state Supreme Court have interpreted how Rule 7B should be imposed or analyzed. They've largely held that sentence modification at the appellate level should be handled if there's what's referred to as an abuse of discretion at the trial court level. And an abuse of discretion would be if the trial court judge came in there just, full of fury and fire and said, I'm doing this because, it's the longest sentence I could possibly give to you. And I think that, you deserve more time, but this is all I can give you. It's like, that's, unless the judge can justify it otherwise, that's starting to kind of get to that issue. Like, was there an abusive process?
Mm-hmm.
If you're not going to try to modify a sentence on direct appeal, you do have an ability to attack the sentence through what's known as a collateral attack. That means that you are questioning the validity of the sentence for some sort of procedural reason. And you're very limited in how you can go about that too. We get a lot of questions from people who sign guilty pleas who ask about modifying their sentence. Well, if you sign a guilty plea, there is nothing for you to modify.
Right. Right.
The courts of appeals a very long time ago decided that a guilty plea is a contract. It's a contract between you and the prosecutor, and whatever's in that contract is what everybody agrees to. And if your plea agreement says you're going to do 5 years, then you're doing 5 years. You cannot modify that. The way that I explain to people when they come to our office and ask about those questions is, if you go down to your local car dealership and you agree to pay $100 a month for the car, and 6 months in you say, well, I can only pay $50 right now. It's like, you can absolutely pay $50 a month for the car if the dealer agrees to it.
Right.
Because that's another contract. And as you can imagine, you can get you can absolutely 100% get a prosecutor to agree to change the terms of the plea agreement and put that back in front of the judge. And if that happens, the judge is going to shrug his or her shoulders, say, okay, whatever. As you can imagine, that's not likely to happen.
Yes.
You had that negotiation, so that's not happening. So a plea agreement, a set term plea agreement, cannot be modified unless the prosecution agrees to it, which is virtually impossible. The more common places where you will see sentence modifications are either you were sentenced after being convicted at trial, or if you have what's referred to as an open plea agreement. An open plea agreement is a type of agreement where everyone agrees, yes, this defendant will plead guilty to this offense. We just don't have an agreement as to what the sentence would be. Judge, we want you to make the determination as to what the sentence is. So it's very similar to what happens if you're convicted after trial. If you go to trial and you're convicted, the judge is the one who gets to make the determination as to what the sentence is. So it's the same situation. You're just removing the trial and admitting that you have guilt. So if you have that open concept on it, if the judge is the one who's determining what the sentence is, the law allows for the judge on a sentence modification to impose any sentence that they were lawfully allowed to impose at the time of the original sentencing. So if you were convicted of a home burglary, which right now, as we're recording this video, burglary in the state of Indiana is a level 4 felony offense. It's got a sentence range of anywhere between 2 years as the minimum sentence and 12 years as the maximum sentence. If you are convicted after trial, the judge can sentence you anywhere between 2 to 12 years on that. If you just say, hey, I am guilty of the burglary, we just don't agree on what the sentence is, we want you to decide what the sentence is, the judge can impose a sentence anywhere between 2 to 12 years on that. That's their discretion with it. So
Sure.
that becomes something that is subject to the sentence modification statute.
Mm-hmm.
Unfortunately, because nothing in the law is ever allowed to actually be easy, there are procedural rules that we have in place in Indiana for the ability to pursue a sentence modification.
Okay.
The first is you are only allowed to have 2 sentence modifications. Or sorry, let me rephrase it. You're only allowed to have 2 requests for sentence modifications.
Okay.
If the judge says, and the judge doesn't have to even have a hearing on that. So you can write to the judge, you can file a motion for sentence modification, and the judge has the ability to deny that without even having a hearing. Like they don't even have to take a look at it, and boom, now all of a sudden you don't have the ability to modify that sentence. That's one of your 2 strikes right there.
Okay.
The other thing is, depending on what the offense is, if you are more than 365 days from the day of your sentencing, you may need to get the prosecutor's permission to even have a hearing on that.
I was just going to ask you
Yeah.
about, where the prosecutor falls in this place. So, okay, continue.
Yeah, it is from a separation of power standpoint, from a fundamental fairness standpoint, it is absolutely ridiculous that the prosecution would have any authority over whether or not the court can modify its own sentence.
Sure.
I unfortunately was not part of that committee when that change in the law went into effect. I don't think any defense attorneys were part of that committee.
Sure.
But the way the law is written is any offense, if a request is made within the first 365 days, any offense, no matter what it is, the defendant can request a modification, and the prosecution can object at the hearing, but they can't object to actually requesting a modification. If it's more than 365 days from the date of sentencing, any violent offense requires the prosecutor's consent to even have a hearing. And a violent offense that's defined by statute, it encompasses all the important ones that you would obviously think about. Your robberies, your serious injury batteries, any type of assault case, homicides. And the reason that's a problem is, as a practical matter, if you get sent to prison, you go to trial and you're convicted of something like robbery, and you're there for less than 365 days, and you ask the judge to consider you for a sentence modification, you're probably not going to get it.
Sure.
That's an inherently violent enough offense that there's going to be a question on the court's part about how much rehabilitation did you really get within that 365 days. And if the court denies it at that point in time, first, that's one of your 2 strikes that we just talked about. Second, now you need the prosecution's permission to even ask for a modification afterwards. And that's obviously, again, much like asking them to agree to modify their own plea agreement, they're not going to create work for themselves if they don't have to. And that represents a sizable problem with regards to how all of this works out. And that's your soapbox speech about fundamental unfairness and that process. But admittedly, it's very difficult to get the sentence modification. There are a couple of programs that are in there, and these can be part of a sentencing order. Indiana has 2 Department of Corrections programs. There's Recovery While Incarcerated, that's the RWI program, and Purposeful Incarceration. They're not 100% the same. Recovery While Incarcerated, RWI, is a little bit more for people who have substance abuse related issues. Purposeful Incarceration is a little bit more of a catch-all. It can kind of hit all things. Those programs involve substance abuse counseling, parenting classes, educational programs, things of that nature. And those statutes specifically do say that if you are ordered into those programs by the trial court and you successfully complete those programs, you have a right under that statute to ask the court to consider you for a modification. So that can bypass that general structure that we just talked about.
Right. You're right.
And sometimes it's successful. We had a client earlier this year who was ordered into recovery while incarcerated. He had a long history of multiple um, mid to high level drug offenses,
Mm.
and he was ordered into recovery while incarcerated, and we
Okay.
requested a modification of his sentence. And we were hoping to modify him out of the Department of Corrections to
Sure.
something like work release or home detention.
Mm-hmm.
That was not successful, but the judge did take 4 years off of his sentence, and
Okay.
that was at least something. It was better than nothing.
Right. Right. So Jack, a big theme, really, despite us walking through three different, the overarching theme of today's conversation and what happens after a conviction, there are a handful of options that truly exist. It's going through the appeal process, looking at post-conviction relief, and then the third being potential sentence modification. So if there's a few takeaways from this episode for our audience, is that options do exist, and obviously every case is super circumstantial. So based on circumstances of the case, backgrounds, so many things, these options might be more viable for you than another case. Despite, Jack, you saying a few different times, it's tough to find that true success, if you will, in completely modifying somebody's sentence to get them out of their conviction entirely. Whereas right there, case in point that you just had, where the sentence modification effort ended up yielding 4 years off of a sentence time. So all in all, there are options that exist. There are benefits to each one. So Jack, as we bring this conversation to a head here today, of these three different processes that we kind of walk through today, is there one that you see that's more successful than another, or is there one that you find as a criminal defense lawyer that pop up more often than another? What do you see in terms of these three on your regular dealings in the Indiana state law system? Loaded question.
If I were gonna say that one had a greater likelihood of success than another, as far as my personal practice is concerned, I would say that we have had greater success with sentence modification.
Mm-hmm.
And the only reason I say that is that after having done this for closing in on 16 years now, I think, at this point in time, we know enough of the prosecutors in the decision making areas, at least here in Marion County, that we can at least get them to return a telephone call to us. That doesn't mean that they're going to listen to us. It doesn't mean that they're
Sure.
necessarily going to agree with us, but we can at least get a foot in the door to start having that discussion. Because
Mm-hmm.
as I said, prosecutors as a whole, they're not going to want to create more work for themselves. So getting them to go back and re-examine a plea agreement that might have been done, or a sentencing hearing that
Sure.
might have been ordered previously, that's not something that is going to be very easy to convince them to do. We are
Mm-hmm.
sometimes able to get them to do that. So from the perspective of what I see on my trial level practice,
Mm-hmm.
um, that's probably the most successful of the three.
Gotcha.
I do have two very good friends who have appellate level practices, and they're both very good at their jobs,
Mm.
and they have actually managed to successfully fall into that mythical, or not mythical, magical 11% that is actually getting it. So I am completely in awe of them being able to do that. I did two appeals. No, I did three appeals. I've done three appeals in my career. The last appeal, we made what they refer to as bad law. So
Oh.
I decided that appeals were not for me. It's like, so I get that comes up, and it's also fascinating when a case that I worked on at the trial court level gets cited as an appellate decision moving forward.
Mm.
We had a trial 2 weeks ago where the prosecutor used one of the cases that I did the trial on as they used the appeals decision to argue that my
Oh,
position was incorrect. So it's kind of like a double gut punch on that one. We lost it the first time
sure.
around, and then you're losing my loss against me to prevent me from getting our way the second time around too, which unfortunately was successful. That was a bit of a tweak in the nose on that
Appeals
one.
can be a fickle friend, it sounds like, in
They
this
really
case.
are. They really are. But no, it is interesting to see those cases that you've worked on
Certainly.
go up on the appeals and have the decisions come back down.
Absolutely.
But yeah, no. As far as what I would say is successful, I think the modifications are successful. Interestingly enough, what we've found with the PCRs that we've worked on over the years, which again, if you thought that 2 years for a trial sometimes was lengthy, I don't even want to tell you how long some of these PCRs go for.
I believe it.
But what we have found is sometimes based off of what we're doing with the PCRs, we can sometimes springboard that into an agreed modification. And it's always worth proceeding with. It's always worth at least investigating it. We tell people all the time, we are happy to conduct a file review of your case for you and give you our professional opinion as to this is what we think would work, this is what we think is not going to work, and this is what we think the likelihood of success is going to be. Because you don't know until you ask.
Right.
And I would rather, I would rather spend the time talking to a client or the representative of a client, because of course, sentence modifications, PCRs, overwhelmingly those people are incarcerated. I would rather spend the time talking to them, and I would rather take their investment in services and do that review and give them a write-up and let them know this is what I think. And I'm not the authority on it. It's like there are hundreds of attorneys in the state. I don't have the same opinion as most of my colleagues. They may have a different one, but at least you have a knowledge. You kind of have an idea. Someone has looked at this. Someone has given me a write-up, and we're happy to do that. And
a consummate
and
professional looking at it.
Yeah, exactly.
Yeah. So I appreciate you bringing that up, because to really round our conversation out today, Jack, if somebody is interested in that file review, or ultimately just interested in general about you and your dealings at Razumich Associates, they're interested in all what that we've covered on this show, and they want to reach out and start a dialogue in some capacity or another, how would they go about doing that? Where should they travel? Maybe online? Is there a phone number that they should call? How can somebody get a hold of you?
I always tell people the absolute best way to reach our office is to give us a call. The main telephone number here at our office is 317-983-5333. That number is monitored 24 hours a day, 7 days a week, even on holidays. We've gotten calls on Christmas, and I have staff members who, are good enough to sacrifice their time, sacrifice a couple hours of their day on those holidays to make sure those calls get answered. So, no phone call to our office is ever ignored. And then we do have other team members who their job is to make sure those telephone calls are returned as quickly as possible. And that's going to be the best way of doing it. I know that here on Facebook, you can contact us through the website, not the website, the business page. There's one of those click to chat buttons on there.
Right.
So that'll get to us also, but definitely calling us is the best way to get our attention. We strive and we do everything we possibly can to make sure that calls are returned the same business day that we get them. That number again, 317-983-5333.
Fantastic. Well, Jack, thank you so much. Really appreciate your time today. I really did love the conversation surrounding what does come after the conviction. I think most people, conviction's over, it's done with, but it's not really the case here in criminal law. So I appreciate you kind of peeling back the curtain, sharing some industry insights. And look, as always, I'm already looking forward to the next episode. Thanks, Jack.
Same here.
Alrighty, and look, of course, we want to take one more moment to thank you, our audience, for joining us here on today's show. If you liked what you saw, you liked the conversation today, please feel free to like the show, comment, subscribe, share this information with friends and family. At the end of the day, Jack and I are doing this show. We're getting together for these conversations to help enlighten you about the different avenues throughout criminal law, throughout Jack's dealings with criminal law across the state of Indiana. And we would hate to have you miss another episode full of some good conversation. So for Mr. Jack Razumich, I'm Ryan Ruff saying so long, and we thank you so much for joining us on today's edition of Closing Arguments.